A U.S. court ruling allowing the $69 billion Microsoft-Activision merger deal to proceed was a big blow for the FTC last week. The agency's antitrust push and its focus on big tech specifically has been no secret. Today, it paused its in-house trial against that acquisition, opening the door to settlement talks. It's not just tech, though. The Department of Justice and the Federal Trade Commission have both taken on companies and industries from airlines to publishing and national security. Last year's high-profile battle over Illumina's purchase of Grail ultimately landed in the FTC's favor, but only after an appeals process. In that case, the commission said the deal would, quote, diminish innovation in the U.S. market.
All right. Well, protecting this innovation is key for both agencies. Now, the FTC and the Department of Justice have released a draft update on merger guidelines. It will be used to guide its review of deals and determine their compliance with federal antitrust laws. FTC Chair Lina Khan has faced strong criticism from Republicans for the agency's sweeping antitrust agenda under her leadership. Speaking on the guidelines, she says, quote, open, competitive, resilient markets have been a bedrock of America's economic success and dynamism. Faithful and vigorous enforcement of the antitrust laws is key to maintaining that success, end quote. Now begins the process of public review before they are finalized. Joining us now with insight, Jonathan Kanter, Assistant Attorney General of the Department of Justice Antitrust Division. Thank you so much for joining us this morning. So let's get into these regulations. And we have a public review period up until September, correct?
That is correct. So we, because of first of all, thank you so much for having me. It's wonderful to be with you all today. The importance of these guidelines is so significant that we have set forth a longer than usual process for public comment. So it will be 60 days, and that will expire at the end of September. And we're extremely eager for input from the general public, all stakeholders.
And Jonathan, Rochelle here. I'm looking at the guidelines here, the 13 guidelines. In terms of the ones that are the most significant changes that people should be aware of, especially given the success rate of the FTC in trying to address some of these mergers, what do you think are the key standouts among those?
Yeah, so we built these guidelines. First of all, let me say very clearly that these guidelines are not the law. The law has not changed. The law was written by Congress. It's been interpreted by courts, including the Supreme Court. And we built the guidelines and we designed them to provide transparency regarding our agency practice in a way that reflects the law. So these are the first guidelines ever since they started in 1968 to cite to cases, and we do so extensively, to binding and relevant precedents, including from the Supreme Court, because our merger enforcement, our antitrust enforcement is law enforcement, and we want to be guided by the law.
So I guess, it's Julie here, Jonathan. I guess I'm trying to understand then how you use the guidelines, right? If the law exists, then what do the guidelines do?
Yeah, so the guidelines help provide transparency about how we apply the law. So as the agencies, we have to get filings. When parties want to merge, they submit filings to the Antitrust Division and the Federal Trade Commission. We examine those filings to determine if the merger will substantially lessen competition or tend to create a monopoly. That involves an in-depth process sometimes. More often than not, we don't have anything to say about it at all, and most mergers go through without any investigation at all. But in some instances, if mergers threaten competition, we have the opportunity to investigate. And these guidelines explain how we go about applying our legal framework to the market realities of today and focusing on the realities of how markets actually function here in 2013.
So
2023.
It's okay. Yeah. You went back in time a decade. All right. But one of those mergers that was that was in focus, it was the FTC had sued to block this, the Microsoft Activision deal. It's proceeding, are these rules, to follow up with what Julie was asking, is this just lip service?
Not at all. So first, let me say these guidelines are forward-looking in nature. They don't relate to any specific case. The case you mentioned is pending over at the Federal Trade Commission, and I defer to my colleagues over there regarding the specifics of that matter. I will say that we've seen a great deal of success in our enforcement program. We've challenged and succeeded in court in blocking the Penguin Random House Simon and Schuster merger, the American Airlines JetBlue merger. And when we look at the total number of trial victories plus abandonments, either post-litigation or prior to litigation, we've seen success in over 15 transactions. That is, a record that I'm extremely proud of. And one of the things that we do is we follow the facts in the law, and we make sure that we're applying the law using state-of-the-art economics and analytical tools. And that's what we've done in creating these guidelines, is we've built them around the legal foundation that courts are going to apply when we bring cases before them.
And Jonathan, obviously some of these multinational companies here, and sometimes you'll see the EU rule a certain way and take a certain lead. How much are these guidelines influenced by some of the actions that you've seen perhaps taken by the EU on some of these merger decisions?
Yeah, so again, I think the law has not changed, right? The law was written by Congress. It was very clear that if a merger, it's a risk assessment, may substantially lessen competition or tend to create a monopoly, then we have the ability to intervene. And that's what we're doing. And so the guidelines are really designed to help explain how that law might apply or how we might go about investigating as part of our agency practice to apply that law. Now, there's an important nuance here, which is that, and I'll get it right this time, in 2023, our markets look very different than they did 50 years ago when phones had rotors, or even 15 years ago when most people, not my dad, would stop at a gas station to ask for directions. And so
nobody's dad, Jonathan.
Yeah, I know. I'm a dad now, so I'm familiar with that affliction. But I think market realities have changed, and it's important that we're using state-of-the-art economic analysis to apply the law to how markets actually function. And so when updating these guidelines, we've not only made sure to, in our view, faithfully and accurately reflect the state of the law, but we've also made sure to faithfully and accurately reflect the state of market realities in economics and economic analysis as it exists here today in 2023.
So there's some criticism that this is political when you are unfairly targeting certain sectors like big tech. What do you say to that?
So I encourage anybody with those criticisms to read our guidelines, because what you'll see is they're business model agnostic. They don't focus on any specific companies or any specific businesses. It simply says we want to protect and preserve competition. It focuses on competition. And in order to protect competition under the law, we have to make sure that we recognize market realities. Market realities today include data. It includes platform technologies. Markets are no longer two-dimensional and vertical or just horizontal, but they're multidimensional. And this is not just true for consumer tech or enterprise tech. It's true across our economy, healthcare, energy, industrials, fintech. It's everywhere. And so it's important that those economic realities are recognized, and that when we apply the law, we're doing so, again, with understanding of how our markets function today.
Jonathan, speaking specifically about Microsoft Activision, obviously that was a defeat for the department and the FTC.
Well, just very clear, that was an FTC case. It's ongoing, and it's Trade Commission. I can't comment on that, but the department did not have a role in that matter. Okay,
because I was going to ask how do you think the approach could have been different, or what exactly is at the heart there that the court disagreed on that perhaps could have been overcome?
Yeah, again, it was an FTC case, and it is pending.
Jonathan, let me ask you this. So with the rules, what industries or what kind of mergers does this place tighter scrutiny on?
So this is really, again, designed to be focused on protecting competition across all industries. So we've started our analysis with how does competition in this market present itself? And we're focusing on the companies that have market power. We're focusing on mergers that create clogs on competition, that create monopoly power, that extend monopoly power. And that can occur in any industry. It can occur, if you look at our cases, we focused on book publishing, we focused on industrials, we're focusing on healthcare, we're focusing on aviation, and we're focusing on tech. We're focusing on all of it. And so, again, these guidelines are really designed to apply across our entire economy and work to the benefit of the competitive process, which in our view really is a benefit to all Americans and American prosperity.
And Jonathan, just quickly, who is pushing for this? Is this perhaps smaller companies? Are the public really pushing for this?
Yes. We had a public comment process in issuing these guidelines initially to get input on creating them. I think the last time they were drafted in 2010, the comment period generated about 30 or 40 comments. This time it generated over 5,000. And those comments are not just coming from industry trade associations or Beltway insiders. They're coming from nurses, emergency room physicians, pharmacists, independent grocers, workers, citizens who care about these issues. We are hearing continually from businesses, entrepreneurs, that they want the opportunity to start business, and they want to do it in the region of their choice, not just in one part of the country or another. We're hearing over and over, not just from small companies, but from big companies, that they want the opportunity to compete based on the merits of their innovations, their pricing, and their customer service. And so unless you're a monopoly, you actually really do want the opportunity to compete. And you'd be surprised how often we hear from businesses of all shapes and sizes asking us to enforce the law so that we can provide opportunities for companies to compete.
And we'll certainly be keeping an eye on those guidelines and see how many companies actually adhere to them. A big thank you there for taking the time to join us on Yahoo Finance this morning. Jonathan Kanter, Assistant Attorney General of the Department of Justice's Antitrust Division. Thanks so much.
Thanks for having me. It's great to be here.